A woman has filed a $1.75 million lawsuit against a nail salon in Portland, claiming that the salon's poor hygiene practices caused her to contract genital herpes after receiving a manicure.
It was filed in March 5th against the owner and the manager of the salon. It also claims the woman's nail technician did not wear gloves during the procedure, which required the use of a drill and drill bits, storing the drill bit used during the manicure in an Altoids container.
So it wasn't until after the manicure that she noticed that her index finger was infected, and then she became sick. She went to the hospital, and for tests, she then found out and received the positive results that she had genital herpes.
Queen City News Chief Legal Analyst Khalif Rhodes joins us now to discuss this. Khalif, at first glance, this seems like a reach, but maybe not.
I can say it. I mean, it has a number of different things. And at first glance, I can say it was probably not just a reach, but disturbing. I mean, because I'm like, what is going on and how did we get here? But this is definitely unusual, but not unprecedented. I did a little bit of research earlier and found out that there was a similar case in 2002 with a very, very similar facts. I mean, in law school, they would say you look for something that's on point. A case that has exactly the same facts. Lady at a nail salon got genital herpes, sued, won a $3.1 million settlement from a jury decision. So a jury of her peers found out and believed that she had contracted this disease from the nail salon and awarded her $3.1 million. Same situation in this case. You have to be able to prove that it was negligence, that they had done something that was outside of the scope, specifically that they owed her a duty to not infect her with genital herpes, that they breached that duty by giving it to her, and her damages is obviously the herpes. And so this one is, I would say, even though the facts seem very, very weird, it's normal law for how you can prove this case.
Yeah, I'm kind of with Brian on this. You know, when I first heard this, I was just like, you know, my first thing was, is it a reach? How many cases have been out there? My question, though, for you is, a lot of people get their nails done. And if you see behavior that is not something that you want to accept in terms of hygiene, is it your duty then to be able to say, should you put on gloves, or this is being kept in an Altoid tray?
Yeah.
You know, for you to sit there and endure certain things and then all of a sudden claim foul, how does that play?
It really doesn't. I mean, the standard of care, and so it depends on the state. North Carolina is a state where if you've contributed towards the negligent behavior, then your lawsuit is barred. But that's only like one of 4 states that do that. Most other states, they limit the amount of recovery that you can get based on the amount that the other person was at fault. So say, for instance, she should have known that, okay, I could potentially get some type of harm because they're pulling out these medical drill bits out of an Altoids box.
Right.
Maybe that's 2% of the harm. So then she's only limited to receiving 98% of a claim as opposed to the whole 100%.
Right.
North Carolina, again, she would have been 100% barred if she was found to be at fault even a little bit. But that state that she's in, no, it's not a bar at all. And that's most states would not bar her completely from recovering. I mean, but if you're talking about looking in the candy aisle or the mint aisle for your drill that you're going to use on your nail, as you mentioned, you should have known that there could be some potential harm that she would have gotten.
And I also too want to point out, because I get my nails done, you do see that often. A lot of times you do see drill bits in an Altoid container. I don't know why they use an Altoid container, but I've seen it before.
But also, too, you have to have, there's some sort of disclosure. You have to have the medical records of someone who is working. They would have to have the genital herpes to pass that on. So you have to get that information for legal purposes here.
And that's one thing that I looked at, because they talk about that something like genital herpes will not last that long. So if it was on the drill bit itself, it would have died within the 5 or 10 seconds being in the air. And so you were assuming that she would have got it by getting a cut and then that individual touching her. That's why she mentioned not wearing the gloves.
Right.
And so, but the folks that are handling this claim are going to have an investigator do a deep dive. They're going to ask for those records, and those are the types of things that you'll be able to get. I do see something like this potentially settling, but then again, maybe not.
Really?
Like, it's going to be a hard case for them to prove. This is an uphill battle. Like I mentioned, only saw one out there that was similarly situated where you had sued a nail facility for infecting you with this. And so trying to find another type of case like that is going to be hard. And so I don't anticipate this one, like I most of the time say, settle. I would, if I'm advising them, I may say go ahead and fight this one out, because you got to prove a lot of things before you can get to a victory. And even though you've seen one before, that one may have been a one-off.
Right, and 2 things could be true. She had an infection and she has an infection. Thanks, Khalif Rhodes, for your input.